There is a place in the United States of America where you can create a completely anonymous company in less than 15 minutes. No identity verification, no proof of address, no background check, no questions about where your money comes from or where it is going. You do not need to be an American citizen. You do not need to set foot in the United States. You do not even need to speak English. You need a name for your company, a small filing fee, and access to the internet. That place is Delaware, but that's not the crazy part. The crazy part is that this system, this infrastructure of anonymous corporate entities that allows anyone anywhere in the world to hide money behind a wall of legal opacity, has been used to finance terrorism, to launder drug cartel proceeds, to pay the operators of human trafficking networks, to move the money of sanctioned dictators, to hide the assets of war criminals, to fund the purchase of weapons used in mass atrocities. The evidence is not theoretical. It is documented in court records, in Treasury Department investigations, in financial intelligence unit reports from dozens of countries. The crazy part is that the United States government has known about this for decades. Congressional investigations going back to the 1990s documented the problem in extraordinary detail. Financial intelligence agencies produced report after report connecting Delaware shell companies to the worst actors in global crime and terrorism. The recommendations for reform were clear, specific, and technically straightforward. And for decades, nothing happened, because the people who benefited from the system were very good at ensuring that nothing happened. And the craziest part of all, the United States, the country that demands financial transparency from banks around the world, that sanctions other nations for inadequate anti-money laundering controls, that lectures developing countries about corruption and financial crime, maintained a corporate registration system that was less transparent than the Cayman Islands, less transparent than Panama, less transparent than the jurisdictions it publicly criticized as financial secrecy havens. America had built the world's most sophisticated financial secrecy system, and it had built it in a state famous for tax and corporate law that sits 45 minutes from Washington, D.C. By the end of this video, you are going to understand exactly how Delaware became the world's most important financial secrecy jurisdiction, how that secrecy has been systematically exploited by the worst actors in global crime and terrorism, and why it took decades of documented harm before even the most basic reforms were finally enacted. This is the story of the Delaware loophole, and the people who built it, maintained it, and profited from it while the world paid the price. To understand Delaware's role in global financial secrecy, you need to understand why Delaware became the dominant state for corporate registration in the first place. The story begins not with criminals or terrorists, but with a mundane competition between American states for corporate tax revenue. In the late 19th century, New Jersey was the dominant state for corporate incorporation. It had liberal corporate laws that attracted businesses from across the country. Then, in 1913, New Jersey reformed its corporate laws to make them more restrictive. Delaware, seeing an opportunity, positioned itself as the alternative. It developed corporate laws that were explicitly designed to be attractive to businesses, offering management-friendly governance rules, a specialized court system with deep expertise in corporate law, and a culture of regulatory accommodation that consistently prioritized the needs of corporations over other interests. The strategy worked. By the middle of the 20th century, Delaware had become the dominant state for corporate incorporation in America. More than half of all publicly traded American companies are incorporated in Delaware. Almost 2/3 of the Fortune 500. The state collects more than $1 billion annually in corporate franchise taxes and fees, representing approximately 1/3 of its total state revenue. Delaware's financial dependence on its corporate registration industry is so extreme that reform of that industry has been politically almost impossible for decades. The anonymity that makes Delaware attractive to criminals was not designed for criminals. It was designed for legitimate businesses that had reasonable privacy interests. A company developing a new product did not want competitors to know who its owners were before the product launched. An investor making acquisitions did not want the market to move against them before they had assembled the position they wanted. These are genuine and legitimate interests. But the same anonymity that served legitimate business interests also served illegitimate ones. And because Delaware asked no questions about who was behind a company, it could not distinguish between the legitimate and the illegitimate. It simply registered whatever it was asked to register, collected its fee, and moved on. The specific mechanism that enables anonymity in Delaware is the absence of beneficial ownership disclosure requirements. When you register a company in Delaware, you are required to provide the name of a registered agent, a person or company in Delaware who can receive legal documents on behalf of the company. You are not required to provide the name of the actual owner of the company. You are not required to disclose who controls the company. You are not required to reveal who benefits financially from the company's activities. The registered agent is typically a law firm or a specialized corporate services company. These companies exist specifically to provide the minimal presence in Delaware that registration requires. For a few $100s a year, you can have a registered agent maintain your Delaware company in good standing, receive your mail, and forward it to wherever you actually are in the world. The registered agent does not know who you are. Delaware does not know who you are. Nobody knows who you are. You have a legitimate American company, and you are invisible. This invisibility has been exploited in documented cases involving some of the most serious crimes in the world. The September 11 hijackers used American shell companies to move money in the period before the attacks. The 9/11 Commission's investigation documented the use of corporate structures to obscure financial flows. While the specific Delaware connection varied by case, the broader pattern of using anonymous American entities to move terrorist financing was established beyond reasonable doubt. Drug cartels have systematically used Delaware shell companies to launder proceeds from narcotics trafficking. A 2012 investigation by the Senate Permanent Subcommittee on Investigations documented specific cases in which cartel money was moved through layers of American shell companies, with Delaware entities frequently appearing in the corporate chains. The investigation found that in some cases, the same registered agent address in Delaware was used by hundreds of different companies, making it virtually impossible for law enforcement to identify which entities were being used for criminal purposes. Human trafficking networks have used shell companies to receive payments, pay operational expenses, and launder proceeds. The financial flows of trafficking operations, which generate an estimated $150 billion annually in global revenue, require sophisticated money movement infrastructure. Shell companies in jurisdictions with minimal transparency requirements are a critical component of that infrastructure. Sanctioned individuals, people placed on the United States Treasury's list of individuals and entities whose assets are supposed to be frozen and who are prohibited from accessing the American financial system, have used Delaware shell companies to circumvent those sanctions. The opacity of Delaware corporate structures makes it extremely difficult for financial institutions to identify whether a sanctioned person is the ultimate beneficial owner of a company they are doing business with. A particularly well-documented case involved Victor Bout, the Russian arms dealer known as the Merchant of Death, who supplied weapons to conflicts across Africa and the Middle East. Investigations into Bout's operations revealed the use of multiple layers of shell companies across different jurisdictions, with American entities including Delaware companies appearing in the corporate chains used to move money and obscure the ownership of aircraft used to transport weapons. The Azerbaijani laundromat, a money laundering operation that moved approximately $2.9 billion out of Azerbaijan between 2012 and 2014, used shell companies across multiple jurisdictions to obscure the origin and destination of funds. Investigations revealed American shell companies in the corporate chains, with Delaware entities providing the American veneer of legitimacy that made the money appear to have a connection to the world's largest economy. The Panama Papers and subsequent document leaks from offshore law firms revealed the systematic use of shell company networks that frequently included American entities. Delaware companies appeared repeatedly in the ownership chains of the offshore structures used by oligarchs, kleptocrats, and tax evaders from around the world. The American entities provided a combination of legal legitimacy and financial opacity that no purely offshore jurisdiction could match. The Financial Action Task Force, the international body responsible for setting global anti-money laundering standards, repeatedly rated the United States as non-compliant with beneficial ownership disclosure requirements. America was on the same list of inadequate jurisdictions as countries it publicly criticized for enabling financial crime. The irony was documented, criticized, and essentially ignored for years. The lobbying infrastructure that protected Delaware's anonymity from reform was formidable. The corporate services industry, the registered agents and corporate lawyers who earned their living from maintaining Delaware companies, was a well-organized interest group with significant political influence in the state. Delaware's senators and representatives, regardless of party, consistently worked to protect the state's corporate registration industry from federal reforms that would have required transparency. The privacy interests of legitimate businesses were invoked consistently and effectively to resist changes that would have been straightforward to implement. Arguments about the compliance burden of requiring beneficial ownership disclosure were made by industry representatives who simultaneously managed compliance systems of extraordinary complexity for other regulatory purposes. The national security agencies that documented the use of shell companies for terrorism financing and sanctions evasion were in an awkward position. They needed the cooperation of the financial sector for their intelligence gathering. Pushing too hard for reforms that the financial sector opposed risked damaging relationships that were valuable for other purposes. The result was that national security concerns were documented but not acted upon with the urgency the documentation would seem to require. Reform finally came in limited form with the Corporate Transparency Act of 2021. This law, enacted as part of the annual Defense Authorization Bill, required for the first time that companies disclose their beneficial owners to the Financial Crimes Enforcement Network, a bureau of the Treasury Department. The disclosures would be maintained in a database accessible to law enforcement and financial institutions under certain conditions. The Corporate Transparency Act was a genuine improvement. For the first time, the United States had a federal beneficial ownership registry. The principle that anonymous shell companies were incompatible with a functional anti-money laundering regime had finally been accepted in law. But the implementation was complicated and the exceptions were significant. Existing companies had years to comply. Small companies with fewer than 20 employees and less than $5 million in revenue were initially exempt. The database was not publicly accessible, meaning journalists, researchers, and civil society organizations that had done much of the investigative work exposing shell company abuse could not use it to continue that work. And then in 2025, federal courts began issuing rulings that challenged the constitutionality of the Corporate Transparency Act's reporting requirements. Legal challenges brought by business groups argued that the federal government did not have the constitutional authority to require state-registered companies to disclose their owners to a federal database. The constitutional questions were genuine, and the litigation was ongoing, creating uncertainty about whether the reform that had taken decades to achieve would survive legal challenge. The story of Delaware shell companies is ultimately a story about regulatory capture at its most complete. An industry that depended on opacity created an ecosystem of political relationships, legal arguments, and financial dependencies that protected that opacity from reform for decades. Even as the documented costs in terrorism, drug trafficking, human trafficking, and sanctions evasion accumulated. The people who built and maintained this system were not themselves criminals. They were lawyers, lobbyists, politicians, and corporate service providers who were doing exactly what their professional and political incentives rewarded them for doing. The harm was diffuse, distributed across victims in dozens of countries, mostly people who had no political voice in Delaware and no ability to influence the calculations being made in Dover. The reforms that have been achieved represent genuine progress. The reforms that have not been achieved represent the continued operation of a system that provides meaningful assistance to some of the most harmful actors in the global economy. Somewhere right now, a Delaware company is being used to move money that funds something terrible. The company was registered in less than 15 minutes. Nobody knows who owns it, and the registered agent is forwarding the mail. If you believe the public deserves to know where the money actually goes, subscribe. Every week, we cover the frauds, the scandals, and the financial crimes the system would rather you forget.